You walk off your international flight, tired, relieved, almost home, and then it happens. A Customs and Border Protection officer pulls you aside. Not because you did anything wrong, but because of something you simply didn't know. Right now, thousands of travelers, like including green card holders, visa holders, and even some U.S. citizens, are getting flagged, detained, or turned away at American airports. And the reason? Policies and procedures that changed quietly without much media attention. If you are flying into the United States or planning to, you need to watch this video until the very end. Because what you don't know at the airport could cost you your entry, your visa, or your future immigration case. Welcome back to Global Immigration Scope, your trusted source for accurate, up-to-date immigration news from around the world. Today, we are breaking down something that is directly affecting travelers arriving at U.S. airports right now. We are talking about enhanced screening procedures, new enforcement priorities, changes to how border officers interact with travelers, and what your rights and responsibilities actually are under current U.S. law. This update is based on information from official sources, including U.S. Customs and Border Protection, the Department of Homeland Security, U.S. Citizenship and Immigration Services, and recent policy guidance issued by the federal government. We are going to lay it all out clearly, simply, and honestly. No panic, no exaggeration, just the facts you need to protect yourself and your family. What happened? Since early 2025, U.S. Customs and Border Protection, or CBP, has significantly increased its enforcement activities at ports of entry. This includes international airports like JFK in New York, LAX in Los Angeles, O'Hare in Chicago, Miami International, Dallas-Fort Worth, and others. CBP officers have been given broader discretion to conduct extended secondary inspections. They are asking more questions. They are reviewing phones, laptops, and social media profiles. They are cross-checking immigration histories more carefully than before. And they are applying stricter scrutiny to travelers from a wider range of countries. Why it happened? This shift is part of a broader immigration enforcement policy put in place under executive directives issued in 2025 directing federal agencies, including DHS and CBP, to prioritize border security and enforce immigration laws more aggressively at every point of entry, not just the land border. The policy expanded what CBP officers can do when they encounter travelers with certain visa types, past immigration violations, criminal records, even minor ones, or ties to countries flagged under enhanced screening protocols. When it took effect, these changes began rolling out in January and February of 2025 and have continued to be expanded since then. As of right now and in 2026, they remain fully in effect, and there are no signs of them being reversed in the near future. Who is affected? This is the part you really need to hear clearly. The following groups of travelers are facing increased scrutiny at U.S. airports. 1. Visa holders. That includes F1 student visas, H-1B work visas, tourist B-1, B-2 visas, and others. If your visa has any irregularities in your travel history or application record, expect more questions. 2. Green card holders, also called lawful permanent residents. Many people assume a green card guarantees re-entry. It does not. CBP can still question you, conduct secondary inspection, and in serious cases, begin removal proceedings. 3. Travelers with prior immigration violations. If you have ever overstayed a visa, been previously deported, or have an old immigration court case, you are at a higher risk of being flagged. 4. Travelers from countries with heightened security concerns. Without naming every country, CBP is applying additional scrutiny to nationals from certain regions in the Middle East, Africa, and parts of Asia. 5. Anyone carrying large amounts of undeclared cash or goods. This is a customs issue, but it can very quickly become an immigration issue if CBP believes something doesn't add up. Number 1. Secondary inspection is real, and it's increasing. When you land and go through passport control, most travelers go through what's called primary inspection. That's the standard booth where the officer checks your passport and lets you go. But CBP can, and increasingly does, send travelers to secondary inspection, which is a separate area where officers conduct a more detailed interview and can search your belongings, including electronic devices. You do not have the right to refuse a secondary inspection. If CBP sends you there, you must comply. Refusing or becoming hostile can lead to detention or denial of entry. Number 2, CBP can search your phone and laptop. This is the one that surprises most people. Under current U.S. law, CBP officers at ports of entry, including airports, have the authority to search your electronic devices without a warrant. They can look at your photos, messages, emails, apps, and even social media accounts. If they find content that raises concerns, like anything from immigration fraud indicators to criminal activity, it can be used against you. But what should you do? Before traveling, know what is on your devices. If you have private or sensitive content that is legal but that you do not want searched, consult an immigration attorney about your options. Number 3, visa revocations can happen before you land. This is critical. In recent months, there have been cases where travelers boarded their flight with a valid visa, and by the time they landed, that visa had been revoked. CBP and the State Department can revoke visas in real time if new information becomes available. If your visa is revoked when you land, you can be turned around and put on the next flight home. You will not be allowed to enter the United States. Number 4, green card holders. Know your rights and risks. A green card, officially called a permanent resident card, gives you the right to live and work in the United States. But it does not make you a U.S. citizen, and it does not give you an automatic right of re-entry. CBP can question you about your ties to the United States. If you have been outside the U.S. for more than 6 months, they may question whether you have abandoned your residency. If you have been outside for more than 1 year without a re-entry permit, you may face serious problems. Also, and this is very important, if you have a criminal record, even for minor offenses, you should consult an immigration attorney before you travel internationally. What seems like a small legal issue in the U.S. can have major consequences at re-entry. Number 5, what you say matters a lot. CBP officers are trained to notice inconsistencies. If your story changes, if you seem nervous and give conflicting answers, or if what you say doesn't match what's in your records or on your phone, that raises red flags. You have the right to remain calm and answer questions clearly and honestly. You do not have the right to lie to a federal officer. That is a federal crime. But you also do not have to answer questions beyond what is required for your admission. If you are a green card holder or visa holder, and you are unsure about your rights during secondary inspection, you can ask to speak with an immigration attorney. CBP is not required to wait for an attorney before questioning you, but you can request one. So what does all of this actually mean for you? For tourists and short-term visitors, the impact is mostly about preparation and awareness. If you are coming to the U.S. on a tourist visa for a genuine visit, you will likely move through the airport just fine. But make sure your travel history is clean, your purpose of travel is clear, and you can explain your visit simply and honestly. For international students, if you are on an F1 visa, your record at your university matters. If you have a gap in enrollment, a change in school, or any issues with your student status, CBP can see this. Make sure your SEVIS record is up to date and active before you travel. For H-1B and work visa holders, your employer sponsorship and your job continuity matter. If your job has changed, your visa may have implications. Always carry your employment authorization documents when traveling. For green card holders, the stakes are the highest here. A green card is not just a card, it is a legal status that can be challenged. Every international trip carries some level of risk, especially if you have a complicated immigration history or a criminal record of any kind. For asylum seekers and refugees, arriving at a U.S. airport and requesting asylum remains a legal right under both U.S. and international law. However, the process has become significantly more difficult, more scrutinized, and more subject to delay and detention than it was just a few years ago. The overall picture is this. The U.S. airport, which for many people is the final step in a long immigration journey, has become a much more intensive screening environment. Being prepared is not optional anymore. It is essential. Now let me give you my professional read on where this is heading. Based on what we are seeing in federal policy direction, congressional discussions, and DHS operational guidance, I expect three things to continue in 2026 and beyond. First, expanded use of technology at ports of entry. CBP is investing heavily in biometric screening, AI-assisted document verification, and real-time database cross-referencing. This means faster identification of travelers with flags in the system and less room for inconsistencies to go unnoticed. Second, more international data sharing. The United States has information sharing agreements with many countries, and these agreements are expanding. What happens in another country, an arrest, a visa denial, a court case, may well appear in U.S. immigration records. Third, continued legal challenges. Civil rights organizations and immigration attorneys are actively challenging some of these new enforcement practices in federal courts. Some policies may be modified or limited by court orders, but that process takes time, and in the meantime, travelers face the current reality. The bottom line from an expert perspective, the U.S. airport screening environment is not going to get more relaxed in the near future. The best protection you have is knowledge, preparation, and, when in doubt, qualified legal counsel before you travel. Let's bring it all together. U.S. airports have always been the front line of immigration enforcement. But right now, they are more active and more consequential than they have been in many years. Whether you are a tourist, a student, a worker, or a green card holder, understanding what to expect when you arrive in the United States is not just helpful, it is necessary. Know your visa status. Keep your documents in order. Be honest with CBP officers. And if you have any complicated history, travel, criminal, or immigration, speak with a qualified immigration attorney before you get on that plane. We will continue to monitor these developments and bring you updates as policies evolve. If you found this video helpful, please give it a like, share it with someone who is traveling to the United States, and leave your questions in the comments below. Our team reads every comment and we do our best to address your concerns in future videos. Thank you for watching Global Immigration Scope. Stay informed and subscribe for the latest immigration news and visa updates from around the world.